everybody. We are on our last panel of the day. It's panel 6, Views from the Federal Defenders. And before we get started, on behalf of the committee, I want to thank all of you for being here this afternoon. If you've sat through any of this, you realize that what we're trying to do is to hear from everyone and take advantage of the opportunity, not only to hear about some of the issues and try to develop the issues, but also ideas. And so we appreciate you all being here. Just a bit of a ground rule. We have received submissions and we ask for those so that the committee can get prepared and ready to ask you questions. So I'd ask you to make a brief opening statement just to sort of summarize where you're at, and then give us the opportunity to ask you questions. Before we get started, let me go ahead and introduce the panel. We have Christian Capicci, the Federal Public Defender from the Southern District of West Virginia, Fred Heblick, Jr., the Senior Litigator from the Federal Public Defender's Office in the Western District of Virginia, Jeremy Kamens, the Federal Public Defender in the Eastern District of Virginia, Brian Kornbrath from the Federal Public Defenders, the Northern District of West Virginia, and A.J. Kramer, the Federal Public Defender from D.C. So with that being said, we'll start with you, Mr. Capicci.
Thank you. Good afternoon, Your Honors and distinguished members of this committee. Thank you for the opportunity to speak today on behalf of the Southern District of West Virginia in regards to the effectiveness of the CJA program. As noted in my written submission, my sense of the overall health of indigent defense in our district is positive. I am well aware, however, of the distrust that has grown between the defenders, CJA attorneys, and the AO, particularly during sequestration, when, among other things, federal defender organizations suffered layoffs and furloughs, and the hourly payment given to panel members was lowered and then subsequently restored. And so on the one hand, I think the CJA program in my district is faring well, and on the other hand, there is this national movement to achieve independence for defenders. Often, I feel like I'm driving a new car. It seems to be perfectly fine when suddenly the engine light has gone on. I'm unsure whether the car has a serious underlying expensive defect, or perhaps the car simply has a faulty engine light indicator, a quick and inexpensive fix. I do think there is room to improve the structure of the CJA program, as I discussed in my written submission. I think there should be a national chief federal public defender position to serve as a dedicated advocate for the CJA program, separate and apart from the AO and the judiciary, and whose focus is on substantive issues affecting the practice of criminal defense in federal courts. I also think voucher reviews should be handled by the CJA supervising attorney within a district, along with support from, when appropriate, the defender, CJA panel representative, and the circuit budgeting attorney. As for complete independence, I am hesitant to support this laudable goal. I side with those defenders who are concerned about creating a completely separate federal bureaucracy and funding the same when it does not appear that the fiscal and political environment at this time would support such a plan. In sum, I am grateful for the opportunity to participate in this process, and I look forward to participating in the discussion here this afternoon.
Thank you. Mr. Heblick.
Thank you. I appreciate the opportunity to appear before the committee and the seriousness with which this review is being undertaken. As a country lawyer, I'm not sure I can bring a lot to this discussion, but I had 15 years of experience as a CJA panel attorney before I joined the Federal Public Defender's Office. So I've had firsthand experience with all of the many challenges that you've probably heard about with going to judges for resources and trying to get experts and trying to get co-counsel when necessary and so on. And I've also seen it from the other side, which is the defender's office, which is where we have resources that are built in, and we're able to represent people, I think, much more effectively than the CJA lawyers are able to do so. When I prepared to come here, when I was thinking about this, initially it was from my own parochial view of my own district. And I've read a lot of the submissions that were sent to the committee. I've read some of the transcripts of testimony, reviewed some of the reports, the 1993 report and so on. And I was prepared to come in and say, you know, things are really pretty good in my district. And a lot of people said that. A lot of people said, well, you know, we had some problems, but we were dealing with the problems, and they're really not that bad, and we things can get better. But after having read everything and seeing the difference in district to district, and even division to division, with how the CJA program is administered and how it's handled, I just don't see how you can ever hope to have an effective program unless there's some uniformity and some standardization. It can't be just one district to district or division to division. And I don't see how you can have that kind of uniformity and that kind of standardization as long as the judges are involved in it. I just don't see how either the judges are going to have to learn how to employ standard and uniform procedures and practices, or else not be involved in it. And I just don't see how there's any alternative to removing the judges from it and having an independent defender service of some sort to administer the program.
Thank you. Mr. Kimmons.
Thank you. I know this has been a long day for all of you, and I want to thank you for your service. I'm sure the travel is difficult, and sitting in these hearings is hard, but it's a very important mission that you have. I come from the Eastern District of Virginia, which has a very large criminal docket. It has, last year, we had about 2,900 cases assigned to my office. There were about almost 600 appointments to the CJA panel. We don't have much role in the administration of the panel. And I want to start by telling you just a short anecdote that a district judge recently told me about a case that he had. 14 defendants, capital charges, very difficult, complex case. And he met with the federal defender at the time, Michael Nachmanoff, who you've met. And he met with the case budgeting attorney from the Fourth Circuit. And they took the budgets from the 28 lawyers, and they reviewed them, and they came up with a proposal that everybody agreed upon. And they submitted it to the Fourth Circuit, expecting that it would be accepted. It was not. It was slashed by half. And it was a shock to the lawyers, it was a shock to the district judge. And the district judge responded by writing a very detailed letter explaining why this was a reasonable request, why it was necessary for these lawyers to have these resources. And he wrote, I think that the limits you imposed, with all due respect, constrain defense counsel's function in a way that will irreparably impair preparation and defense of the case. Now, this is a success story because the chief judge reconsidered and he approved 99% of what the district judge had asked. The problem is that this success depended upon the advocacy of this district judge. And it's very possible that another district judge would say, well, that's too bad. The success of the funding of indigent defense often depends upon the able advocacy of district judges. But as my colleague, Mr. Heblich, just said, it's not uniform. And it's hard to hear the testimony of Mr. Shea, the CJA lawyer from Boston earlier today, or read the written testimony of Steve Asen and Dick Wolf, who will testify tomorrow, or to hear this story and not think that there is some tension, some difficulty with the placement and the administration of the CJA within the judiciary. Now, all of that said, I'm realistic. I read after the Judge Prado's report was issued. He wrote a law review article, and in it he wrote, "A sense of momentum has been achieved." There may be some debate about that. But there were many positive things that came out of that report. CJA plans were reformed, updated. The Judicial Council adopted many of the recommendations. And so, although there is this debate that is rampant amongst federal defenders about independence outside the judiciary and within the judiciary, and I have views on that, I'm also realistic about the practical results that will occur from what this committee does. And I hope and believe that the recommendations made by this committee will have an important impact on the administration of justice in my district.
Thank you. Mr. Kornberg.
Thank you, Judge Cardone and committee members. In
Can
preparation
I
for...
ask you to pull the mic?
Yes. In preparation for today's appearance, I spent quite some time looking at the archives, the written remarks already provided. I'll keep my opening remarks brief. I think anything I say is going to essentially mirror what other people have said to the committee already. I have been the federal public defender since 2002. Before that, it was 6.5 years as an assistant federal public defender. So for about 14 years now, I've managed our defender office in the Northern District of West Virginia, as well as the CJA panel. I'm giving you a local snapshot. I don't think that the program is broken in our district. It operates quite well. There's quality criminal defense representation readily available. With the exception of sequestration in 2013, we see that funding and support has been fairly consistent. Nonetheless, I think changes in oversight and operations at the national and district levels might well be in order. That's up for this committee to decide. I think this committee understands that the complexion of federal criminal defense has changed over the years. You know, prior to 2005, when we had a mandatory guideline scheme, you know, we were up against that Orwellian platitude, greater fairness through uniformity. And thankfully, post-Booker, that's no longer the case. You know, we have an adversarial system where we fight over guilt and innocence, but we also have meaningful mitigation now, where we can paint, you know, a true holistic picture of the person that's before the court about to be sentenced. We have drug courts, reentry courts, informal programs where we're trying to lessen recidivism. So you're leaving that adversarial battle, if you will, and you're coming into a more collective cooperation system with the other court units trying to do what's best for the client. On the front end, where you're getting the variant sentence with reintegration into the community, and then with the supervised release cases where you're trying to come up with something than a return to federal prison. I think now experienced, able, well-funded criminal practitioners are more important than ever. The prospects for continued success hinge on a symbiotic relationship between federal public defender and community defender offices who've got to work closely with the CJA panel attorneys in the court. It's going to require a proper balance, both nationally and locally, between necessary oversight and the independence needed to fully implement the defense function. I will say I'm honored to be part of such a program, and I welcome any questions that the committee has. Thank you.
Thank you. And Mr. Krim.
Thank you, Judge Cardone, and it's an honor to be before this committee. I have the greatest respect for it, and most notably your stamina, listening to so many people go over the same things. I think I should tell you something about how you can judge my credibility. Recently, I had to speak at the courthouse at an event, and I was introduced by the chief judge as they had checked the records. I had tried and lost more cases in the United States District Court for the District of Columbia than any other lawyer. I had argued and lost more appeals in the United States Court of Appeals for the District of Columbia than any other lawyer. And I topped that off with a 9-0 loss in the Supreme Court. So you can judge my credibility from that. I do feel compelled to say I admire the work of this committee. I feel compelled to say at the beginning, the real shame in the criminal justice system in the United States is the quality of death penalty representation at the trial level in many state and local courts. And I'm sorry, as well as the funding for many state and local public defenders, where you find out that people have 300 felony cases, including 5 death penalty cases. And I'm sorry there's not a committee and a commission studying that, and it receives very little attention for whatever reason, even though 90% of the cases are prosecuted in state courts. I know that this committee has nothing to do with that, but I feel compelled to say that for my colleagues in far more unfortunate situations than we are. You've heard about our district from Mr. Broadnax, and I don't really want to repeat anything he said. We administer the panel for both the district court and the Court of Appeals. There's no voucher cutting. The attitude of the courts of appeals judges who are designated to review vouchers is that if it's good enough for the district court, they're the ones who know the case. How am I going to say anything different? That's good enough for me, so that works well. We obtained for the district court in DC, which you heard about the Guantanamo habeas cases. We obtained federal defenders from all over the country to represent them so that Guantanamo detainees had incredibly high quality representation in the habeas cases, not the military commission, but the habeas cases. So again, I can repeat that it seems to work well in our districts. The federal defenders seem to me, I'm not aware of any claim that representation in a federal defender case has been hurt by a lack of resources. I have much more question, and it seems to me, just like I said, the real problem in the criminal justice system is the state and local. The real problem in the federal criminal justice system seems to me to be the panel lawyers who are woefully underpaid. Why the circuit has any role in reviewing the district court vouchers is beyond me. I thought it was an appeal but it's been interpreted that they can't increase the amount, they can only decrease, which seems to me to make no sense. And then it's having to go for resources for investigators. And I'm happy to say that when I saw the figures, the District of Columbia was one of the highest, if not the highest, district for use of experts and other service providers. So I really think that and of course there's problems with the structure and the oversight and the power that's exercised, but the real problem seems to me in the federal criminal system to be with the panel lawyers. So thank you very much, and again, as with everybody else, welcome your questions.
Thank you. We'll start with Professor Carr.
Thank you all for your testimony, both oral and written. A.J. Kramer, I want to start with you. You mentioned your view that the panel attorneys are I think, the area needing the most reform in the federal system, and I was hoping you could say more about what specific reforms you would adopt. You mentioned the question of the role of circuit judges reviewing the district judge vouchers and those decisions. So that's one area. Do you have sort of broader views or anything in more detail about broader reforms you would make? A lot of ideas have been on the table today about giving the defenders certain roles, and I guess in D.C. you take on a lot of those roles. Is that the right way to go? Or are there other, sort of go riff on changes you think would improve the system?
I mean, the hourly rate is clearly, and especially in a place like DC, the hourly rate, whatever the national average is, we heard 90 some odd dollars an hour. It's orders of magnitude higher than that in places like DC, New York, Los Angeles, Chicago, San Francisco. So I'm not even clear how many. We're lucky in DC. There's committees, both the Court of Appeals and District Court, that review the applicants, and we have an incredibly high quality panel, I think, on both courts, including a number of lawyers from large law firms. But I think I can give you an idea of the adequacy of the hourly rates. There's a number of those lawyers from law firms that don't even submit vouchers because I think they think I hate to say it this way, it's almost more trouble to submit the voucher for that hourly rate than it is for them to just do it pro bono. That's a sad commentary on the system and unfair to CJA panel lawyers who need the money. So I think the hourly rate is the first thing. I think that the voucher cutting by district judges, we're fortunate in DC that I don't ever recall a voucher being cut just because of budget reasons or philosophy or whatever. There have been isolated instances, I can probably count them on one hand, where vouchers have been reduced because the thought was that somebody, the amount claimed was not reasonable, and even then, the person is given an opportunity either in writing or in person to appeal that to tell the district judge why it should be justified. That's now advisory in the guidelines for the Criminal Justice Act. That seems to me it should clearly be mandatory that a CJA lawyer should have an opportunity to be heard before a voucher is reduced for any reason at all. I don't understand why a judge can't spare a few minutes of their time for a CJA panel lawyer who's woefully underpaid to begin with. I think we're very fortunate in DC because the attitude is the amount's way too low, and we trust our panel lawyers. The panel lawyers have been screened by a committee. I honestly hear, and I've heard, and don't doubt for 1 second, the horror stories in other districts, and cannot understand how a judge cannot, first of all, think that the amount of money when the civil lawyers come in cases and are getting $800,000-$900,000 an hour, even at some firms in DC, and that they should be cutting several hours from a CJA voucher. Also, I just think judges should trust their lawyers, their CJA lawyers, or they shouldn't be on the panel. If a judge, especially when there's been a screening committee for a panel, I don't see that the Court of Appeals really has any role in reducing vouchers for, or even reviewing vouchers for, as I said, for where the district court, who's the one who presided over it. And fortunately, that's been, so I wouldn't, and that would require statutory change. I think most of the others would be within the CJA guidelines. But those are the ones I would start off with. Also, of course, this is a big statutory change, going to the judge for, again, we're very fortunate in DC. I don't ever recall an expert request being denied. Never. And it's done without even a memo. The CJA 21 is just submitted, the judge signs it, and it comes back. And nobody's ever been refused an expert that I'm aware of. People have requested $30,000, $40,000, $50,000 for experts, and the judge might say, take $20,000 to start, and then if you use that up, we'll look at the next $20,000. But nobody's ever been refused an expert. I don't understand why a judge would not trust a CJA lawyer who says, I need an investigator. And to get to an earlier question that was asked, I don't think 100% of our cases involve the use of an investigator or a paralegal or some other person in our office. Go pull criminal records, go talk to witnesses, go see the person at the jail. It's just inconceivable to me that a lawyer could do a case without an investigator, paralegal, and why judges should be questioned. I think the guideline language, if absent a statutory change, the guidelines language should be changed to make it clear to judges that they should not be denying experts without either asking for more information or making clear their reasoning why, and that would be a little difficult for me to conceive.
And do you think there's any value in going maybe beyond that and suggesting, a presumption that there should be an investigator hired, or is there enough consistency in cases to try to say more than just that request should not be denied?
Oh, yeah, yes. I think that's what happens in DC. There's a presumption that you can't do a case without an investigator, especially the high number of people in federal cases that are detained. Just to ask and you've heard all about electronic discovery, I won't repeat that, but to go sit with the person and review that discovery, you need an investigator. And to talk to the person and say what to follow up, you need an investigator. You need a paralegal. You need for sentencing, especially with the increased number of child sexual, either abuse cases, pornography, whatever. You need all kinds of psychiatrists, psychologists. The one thing a judge wants to know is the person going to act on it and actually commit an act against a child, or what's the future going to hold for this person? You can't do that by just looking at the person. You need experts to assess the person. But I don't see why, absent a statutory change, why the guidelines language shouldn't be that we trust our panel lawyers, that they know their case, and there should be a presumption that if a panel lawyer requests an expert, that should be approved.
That's helpful. On the broader question of whether to move towards a independence for the defender function. I read your written testimony, and I wasn't sure if you were saying it's a bad idea or you just haven't seen a good idea yet. I was hoping you could give us a little more of a sense of where you come out.
I'm not sure myself. I'm conflicted. I work inside the Beltway, so I'm all too familiar with how things work. Look, but I do live outside the Beltway, so, look, we were told 2 years ago that sentencing reform was going to be a reality very quickly. It's now been held up for 2 years while in committee, not even in the Senate, in committee, while there's a question of how many of the majority votes in committee you need to get the bill out of committee. And there's been so many amendments, it looks nothing like the original version that went in. So this is my fear. If you submit a bill to Congress, first of all, I don't see this Congress as an opportune time to create a new, and I've heard talk about new positions in every circuit, in every district. That's 110 new people and how boards of governance. And to answer Mr. Friendly's earlier question, I don't like bureaucracy, and I don't like the cost of bureaucracy. And a lot of these plans have a lot of bureaucracy, and I don't trust that Congress won't tinker with the bill with a proposal that gets there and add all kinds of amendments that people are not going to be happy with, and that the Congress people in their district aren't going to want to pick the federal defender in their district. And so I have and there are people in our office, and I know a number of people that work on the Hill, who I think I put in my written submission, said, well, this would be committing suicide for your program. This would be just plain stupid for your program. And that we would go the way of legal services. But all you had to see was the smear campaign that was launched against Judge Jane Kelly when her name became public as possible Supreme Court nominee, and all these ads started running that when she was a federal public defender, she represented somebody and advocated for a lenient sentence, and that person went out and killed a young child afterwards. How many incidents do we think that that's going to take if we're this standalone agency? Incidents like that, it's going to take before Congress starts to do things like that. I'm not saying I'm right or wrong. I'm saying that's what worries me. Let me put it that way, because I don't think I know the answer, unfortunately. And luckily, I'm not on this committee. You're the ones who have to answer that. But I don't think I know the answer, but I'm very scared of it. I'm also, as I told you, very scared of the way things are. It is interesting to me that the Prado Commission was 23 years ago, and nobody thought that there needed to be any review of the system until sequester hit, which was, of course, a congressional action. And all of a sudden, things took and was how that was handled within the AO, there's certainly different viewpoints, but it was a congressionally imposed action, that whether that's an anomaly, and all of a sudden now we're in a situation where we're told we can't spend money fast enough, that we're going to have all this excess money and we should hire and hire and hire. So I worry about both models, and I don't think that I'm the one who has the answer.
Let me open it up to the other members of the panel to the extent whether you feel you have the answer or want to weigh in on either the question of broad independence or how to improve the role of the CJA panel system.
We manage the panel in our district. Suggestions would be have the attorneys go to the district court judge before they reach the limit. In other words, educate the judge with upfront why you need these costs, rather than get a $25,000 bill after the fact that's subject to being cut. I think there should be some type of administrative appeal process, and I don't know the specifics, but I think the case budgeting attorneys at the circuit level working with a similar position at the district level would add another level of review to the judicial decision. E-vouchers going online across the country as we speak, that information is readily available. It's very easy to see whether a case is an outlier or not, based on the charges, the locality, things like that. I think some of the panel attorneys are worried about voicing their frustration. I'd love to see a national clearinghouse where they could report their instances of being gouged without having any repercussions. Those are some suggestions.
With respect to the CJA panel, we don't administer them, and so, I think it's a good idea to have CJA and FPD participation in the selection of panel members. In my district, we have a committee in the Alexandria division that I serve on. There are 3 judges and 2 CJA representatives that review a third of the panel every year, look at applications and reduce the list. That's not the case in the other 2 divisions. With respect to vouchers, we don't have any role to play in reviewing them at all. It gives me pause. I heard all of the CJA representatives say that they would like for the review of vouchers to be housed within the federal defender, and maybe that is the best way to do it. It makes me a little afraid, given the number of cases that we have. That would be significant. It would be a significant increase in the amount of work that we have if we had to review the vouchers from all of the CJA cases that are appointed. But I do think that there should be some kind of independent review of vouchers, either a case budgeting attorney or someone other than the district judge who's handling the case. We do have that a newly appointed person, as the CJA panel rep from EDVA said, in the 4th Circuit for cases that go above the $9,000 cap. The number of CJA lawyers in my district, according to the most recent statistics, who hire, this is not immigration cases, not capital cases, but who have investigators or experts or paralegal assistants, is absurdly low. It's 5%. I think that is probably not completely accurate, but because, and I say that because it doesn't seem to reflect the sort of anecdotal evidence that there are a lot of good CJA lawyers in my district who wouldn't dream of representing a client in a sophisticated case without getting some kind of assistance, some kind of investigative assistance. I will say that I think Professor Gould asked about, say, a terrorism case, material support case. Those types of cases, as a general matter, are either handled in my office or are retained. And if there is a co-defendant, often our office will handle the expert fees. So we share that, and the federal defender pays for those experts. And so some sophisticated cases, for example, we had a piracy prosecution. There was a lot of overseas travel, a lot of experts. A lot of those expenses were incurred by my office and not by the co-defendants. But I do think that there is a lot of self-cutting. That is, CJA lawyers who would prefer to submit a voucher that's under the cap and not ask for fees for expenses that they incur, because they would rather get a prompt voucher than go through the process of having it denied or cut, and perhaps, the idea of reconsideration, or I think a judge here said that you are entitled to due process. Well, I don't know exactly what that means in the context of voucher. Does that mean you get a chance to go back to the same judge and ask again? I think that might be it. I'm not sure that there's any other process. With respect to independence, briefly, I think you have to think about the question first, is this, as a normative matter, is this the system that we should have? That is, does it make sense for judges to decide the funding of one side of the adversarial system? And if you come out of that answer with no, then you have to think about, all right, well, what are the practical problems? What are the logistics of changing that system? And that's extraordinarily difficult and complicated. As Mr. Kramer suggested, I think it's unrealistic in the short term that there would be legislation that would have any hope of actually changing the present structure. That doesn't mean that it's not important to say what the answer is. And the answer, I think, is that we should have an independent system of indigent defense, just as the executive branch, the prosecutors, are independent from judicial scrutiny of their budget. And I don't think that there is much debate about what that normative answer is. The debate is about the practical difficulties that obviously are much harder.
The compensation of panel attorneys is important, but I think what's more important really is training for the CJA panel. And at least in my district, maybe it's unique, but most of the panel members are people who are either solo practitioners or they are in small partnerships or office sharing practices. Most of them, and I know a lot of them, most of them do not have backgrounds either in a defender's office or a prosecutor's office or a government agency or a large law firm, any sort of background where they would have received training, the sort of training, professional training that one gets. Most of them it's a rural area. Most of them are in small communities. And most of their practice is state court practice. It's not federal practice. We've cut out, I think, most of the dabblers. We don't have real estate lawyers doing murder cases anymore. But I think a lot of the deficiencies in the panel is not for lack of ability or lack of energy, but simply lack of knowledge. I'm an adjunct professor at the University of Virginia Law School, and I've been the director of the criminal defense clinic there for 15 years. And I take third-year law students every year, each semester, and I train them to go into court and try cases. And I think a lot of the CJA lawyers, I would like to see there be standards, basic standards, before they could be on the panel. Training courses. The defenders, when we hire a new defender, they have to go to the baby defender training out in Santa Fe every year, which is a week long. And these are people who've had usually pretty significant legal experience before they come into the defender's office. But they're required to do that. Some defenders' offices, I know in North Carolina, I believe the Middle District in North Carolina, or maybe the Western District, they are required, the court requires that the CJA lawyers, when they apply, that they take training courses from the defender's office. But it seems to me that really remedial, and maybe that sounds unkind, but often remedial training would be a big benefit, because their state experience, which is mostly what they're doing, is just abominable. In Virginia, the experience in Virginia is what you heard the military guys talking about, that they get no resources and they have to go in and beg to the judge to get any resources whatsoever, even in capital cases. They have to beg for resources, and they have to do it. They can't do it ex parte. They have to do it in front of the Commonwealth attorney, who always opposes. They never get what they need. They never get what they ask for. They prejudice their case by even asking for the services. And they get told things like, why do you need an investigator? The Commonwealth, didn't they give you they have open file discovery policy. Didn't they give you the discovery? It's like, hey, judge, did you ever hear of the obligation to independently investigate your own defense case? That's what they're used to. So this is why I had the numbers just like Jeremy did. This is my district. I find this a huge embarrassment. This is since 2007. Since 2007, there have been a total number of 35 cases in which a CJA panel attorney got an investigator. 35. I mean, in the district, they can't live without an investigator. And here, they don't even know how to ask for it. we put on, his district and my district put on a training, a 2-day training session every year for CJA and defenders. And we have had programs specifically aimed at the panel members. Here is how you ask for resources. Here's how you get them. Here is how you justify them to the judge. Here are the forms. Here's what you do. And if you have a problem, if you don't know how to do it, call us and we will help you do it. And so this is these numbers. You have 35 investigators, 1 psychologist, 4 psychiatrists, hundreds of cases. And these are, over the past 10 years, in our district, I think as in many, if not most districts, the prosecutions have become more focused on complex, serious cases. So I think that it's not just a matter of the resources not being given by judges. I don't hear those complaints because they're not asking for them. And I think that that's a function of the panel attorneys not being educated as to what is available to them. And I think that is something, it may cost some money, but I think that is something, the U.S. attorneys are forever going to the NAC, they're forever going to training. You hardly ever get a case scheduled because they're training. And, and the defenders have some training, and the defender's office provides training for the CJA attorneys. Our office makes every effort to tell them what's available, but they have to do it. And I don't know what else to do except to encourage them to do it or to require it. And I think if it's required in order to be on the panel, I think they'll do it.
How did they pay for it?
Well, how do they pay for it?
Yeah.
Well,
how
we
did the
would put
CJA
on, we would put on training, and we do that's free. What we do, and I would think that the Defender Services puts on training. Those programs are free. The programs are free, and when I was in private practice, I went to dozens of them all over the country. And you could apply for money for travel, for scholarships. You get I went to death camp for a week. They're dying to have people go get the training, but it's not required.
Well, but there's 10, and I'm sorry to interrupt, but there's over 10,000 panel attorneys. I live in El Paso, Texas. There's very few programs put on where I live. So I understand what you're saying. One of the things we hear is that they need training, but how do we get it to them?
Well, there's a lot of training that's available that's not being taken advantage of. Okay. And I think that through the Defender's Service, that there could be more training. Like I said, I think if it were required, in some districts, there's required training. But again, it's district to district, division to division. If there was some uniformity and there was some training, I think that they would do it, and I think it would lift all the boats, to be honest.
We're in a similar situation in my district where the number of CJA panel attorneys making requests for investigators and experts is quite low. I think in 2015 there were 25 forms submitted to the CJA supervising attorney requesting experts or investigators, less than 10% of the cases. So in our district, the CJA supervising attorney and I have a good relationship, and we've discussed this issue. We've discussed putting together training where the AFPDs in my office will present examples of where they've used an expert or one of our investigators was used. In fact, in our office now, we now assign an investigator to each and every case that comes in, no matter how small it may be or how relatively simplistic it looks at first glance. We've also thought about putting together a database that is accessible only by the CJA panel members, which would include a list and contact information for the various experts that we use. Of course, any of these CJA panel attorneys can always pick up the phone and call myself or one of the folks in my office, but they don't really do it as much as we would like. I also want to just touch upon a point about the makeup of the CJA panel in my district. And I think it's very similar to what is in the District of Virginia Western in terms of the makeup of the types of lawyers who are on the panel. There is a view, and I think it's a good one, a helpful one, to try to bring onto the panel very successful civil litigators, because they have, although they may not have the criminal background, they do understand and they use quite frequently experts. But we're not seeing those folks from the larger firms serving on our panel. Part of that goes to the rate that is paid. But I think particularly in a smaller district, a less diverse district like in Charleston, West Virginia, where the rates that even senior partners charge are nowhere near what may be the case in Philadelphia or Chicago. I think that when I was briefly on the panel for about two years, the problem for me was how long it took for a voucher to get approved, particularly if your compensation at the firm is based on how much money you hand over to the firm. If that voucher isn't paid for many months, it can cause a problem, and I just think that certain attorneys just don't want to bother with it. With the e-voucher system, that has been largely eliminated, that delay, and these vouchers are being turned around very, very quickly, at least at the district court level. I also would agree that the training shouldn't just be, and it appears to me that the focus on much of the training that the defenders put on for those in my office and CJA panel seems to be focused on sentencing, which makes sense with the post-Booker environment. But it always bothered me when I was getting ready for trial as an AFPD and the prosecutor somehow disappeared for a week, and they would go to this super secret facility called the NAC, and they never told me what they were going there for, and to this day I don't know what they're doing, but I get a sense that they're practicing to try the case that I'm about to try myself. We don't have something similar to that for defenders and CJA panel attorneys, so maybe we need to have a super secret facility where we try and practice these cases. But again, these are issues that I do see in my district, and we are trying to address them within the district.
Thank you.
Dick Prado.
I'm tempted to say something about Mr. Kramer, but I will not. Maybe one of the first things we got to do is change public defenders. In D.C., his record is so bad, but he had that coming.
Don't ask the rest of this.
We've heard a lot of testimony about problems that panel attorneys have. And I think we're in agreement something has to be done about helping them out. But community defenders and public defenders, separating the two, have any of you, and if you feel uncomfortable discussing it, fine, but have any of you experienced any interference by judges or the courts in your particular offices that you feel independence is necessary from the courts? I know that the circuit court appoints the defenders and gives you staffing, and the community defenders have their boards, but has anyone experienced in your particular offices any interference from the courts with how you're handling your cases or the docket or things of that nature that you felt that the judge might have been out of bounds in trying to suggest to you how you might run your office?
I don't think you're going to have a lot of people jumping up to respond to that question.
You don't have to mention any details. I'm just curious if we have how significant that problem is. We've heard some concerns in some districts, but I don't know if it's just some isolated districts or overall, is there a problem with the way the judges are working with your offices?
I would say no. In my district, we've had very supportive judges. I will say that Mr. Hedlick just had a trial. It was a trial that was in the Western District. It was started out as a capital case, and so they needed capital lawyers to handle a lot of the defendants. So some lawyers from my office were appointed to be involved in that case, along with CJA lawyers. And we had 2 lawyers from my office, and there was also another lawyer who was appointed, so that there was dual representation. And in the middle of jury instructions, the judge, and this is not in my district, but said, I only appointed 2 lawyers to this case. I will not allow this lawyer, second lawyer from the Federal Public Defender's Office, to participate in the trial. She can sit outside the well, she can assist, but she won't be allowed to cross-examine or participate in the testimony, adducing testimony or cross-examining any of the witnesses. Now, this is a case that started as a capital case. It went to trial. There was a mistrial. It was continued for a year. These people had been working these 3 lawyers have been working for a couple of years on this case, and they had divided up the witnesses between the 3 lawyers. And the 3 lawyers went down to 2 in the middle of jury selection. And I think the reason was that the judge felt that it was his job to determine how the resources were apportioned to the defense like he ordinarily would in a case involving CJA lawyers. And he viewed, in this case, he had appointed 2 lawyers and felt, I don't need to have another lawyer from the Federal Public Defender's Office there. My view is that in terms of those resource decisions, those are up to us as a general matter. Just as a judge wouldn't tell a prosecutor, usually, you can't put that many resources to prosecute this particular case. As a general matter, the judge can't tell the federal defender how many resources they're going to put on a case.
Was the judge notified about this ahead of time?
I'm sorry, notified? I mean, it happened, I think there was shock, and then there was objection, and then there was a written, or there was objection, and there was discussion about this, and the ruling stood.
The lawyer.
I wasn't there, Fred was there.
The lawyer, and I feel bad about this, because I had asked, this was a 10-defendant RICO murder case with 4 capital defendants, and I asked the district judge to appoint, to go to the Eastern District and bring over a lawyer, because I didn't want to have to try the whole case myself, which I knew it would happen. And I occasionally have to go sent over to the Eastern District, where I have the judges eating out of my hand, just like Jeremy does. And so we've done that, and so they agreed to do that and bring
They agreed, you mean?
the judge agreed to request that the defender's office from the Eastern District come over, so that we had 2 defenders representing 2 capital defendants, so that, as I said, it was, and the lawyer who he removed had made, she had been hired by their office. The case went to trial, and there was a mistrial. And then when it came back, during that time between the mistrial and when it was tried, the other lawyer that was hired by their office and made an appearance, was on record, but had not done anything, hadn't appeared in court, but had noted an appearance in the case, and there had been no argument about that or no issue about it. And then in the middle of jury selection, when she got up to voir dire the jury, this issue came up.
Okay. Anyone else had any feelings where you think the judges might have interfered in how you run your office?
Just, Your Honor, on record, no. I am in a perhaps honeymoon period. I've been the defender for 15 months. I would say that the judges are very supportive in the sense that they, I think, are trying to take steps and make comments that elevate the practice in the district and are in many ways very protective of the defendant in the case, and ensure that the defendant, whether the defendant is represented by a federal public defender or CJA panel attorney or a retained counsel, are doing the best. And so in that sense, I and the folks who practice in the Southern District are very, very fortunate.
I think our judges are very supportive with our office, but, you know, it's a symbiotic relationship. We're responsive to the court's needs, and it's vice versa. I mean, if I could exaggerate to make a point, you know, if tomorrow I become an anarchist with a briefcase and demand that my attorneys try every case, forget about acceptance, file frivolous motions, you know, act unprofessionally with the other court units, I'm not getting reappointed in 4 years. It's the handwriting's on the wall. So with that said, there's got to be a common sense cooperative effort from all parties involved. Otherwise, it's not going to work.
I guess, along with Mr. Kramer's testimony about being concerned with changes, I'm wondering if, in recommending changes because there's a problem, how big is a problem, and is the solution fit the problem? Are we going too far over with total independence, somewhere quasi-independence, or where? Because my other question is, where are we going? What are we going? What are we going to establish? Is there any model in place that we can say, look, it's worked, here's an example of a situation that's worked, and we should go to that model? Are we going to find ourselves recommending an unknown thing? We think this is better because it's got to be better than what we have, but we're not sure what it's going to lead to. And I'm afraid we're going to get questions back, well, you're making this suggestion, how do you know it's going to work any better? We've heard possible problems with a system that's not been proven yet, I guess, in recommending something. I guess that's my concern, is there needs to be a change, but what is that change, and is there some model that we can go to? We heard from the military. I don't know that that's going to work. The DC defenders, their budget is so small, I think it just passes under the radar. A defense budget would be much larger, and I think with helping panel attorneys, the budgets, if we're going to give them what they really need, the budget's going to need to get bigger. So would an independent board sell? And I guess that's my concern, is how bad is the problem, and how big should the solution be? Does anybody have any ideas as to what would be a good model for us to look at that might be a solution to the problem?
Well, I think we just get rid of the current system and replace it with something really great.
Even the defenders can't agree among themselves about the perfect model.
Can you, I ask you to speak to the microphone?
I'm sorry. You know, we have disagreement among defenders about what the solution is. You know, we're in Philadelphia. If you look at the Declaration of Independence, there were very discrete complaints that justified complete severance with England. I don't think it's reached that point. I think there are changes that can be made where you don't have to have that independent, separate entity that's outside the judiciary. But that's just one of many opinions.
I mean, it was interesting to me, Judge Prado, at the time of your committee, there were these howls that the last thing in the world we want is a defender general. That would be just a horror story where we'd lose all kinds of autonomy in our offices, and that's the last thing, and that vote was overwhelmingly against any kind of thing like that amongst the defenders at the time, and that we could never live with a defender general, and now I hear defender general being proposed as a solution to the problem. So I think that's why I'm so schizophrenic about the whole thing, and I realize that I may not be visionary enough, but I think you have to combine vision with reality at some point, and I think that's what you're asking about, and I certainly don't feel like I have the answer to it.
Well, I think the situation's still there, that was there many years ago, and we still need to do something. I'm not sure what it is and what will sell, and how far we should go in making a recommendation. In an ideal world, I think total independence is the way to go. in the real world. And I guess we're looking for some guidance, but you guys can't agree among yourselves as to what should be done. The courts are slow to change. And we have to make a presentation to the AO and the Judicial Conference and try to convince the judges that they haven't done a very good job of running the show. So maybe more independence is necessary in how we go about in trying to convince my colleagues that a change needs to be made is going to be a challenge for us. I'm looking for some sort of guidance as to how we go about doing that.
The public defender service model is probably the most closely analogous. If the concern is the size of the program in the grand scheme of the federal budget, this is a $1 billion program, relatively modest. It could be, if there were some guarantee that funding would be secured at that level or higher as a fraction of the budget of, for example, DOJ, then the concern about funding would be addressed because it would remain at that fraction as a matter of DOJ's budget in terms of calculating how much it would be.
There's certainly a lot of talk in Washington recently about cutting DOJ's budget by $1 billion or more. So then what happens? Then we get reduced at that point. I mean, of course, in theory, complete independence, of course, is I don't see how anybody could frankly argue against it in theory. But reality intrudes at some point, and Congress isn't going to guarantee a level of funding. And what happens when if DOJ's budget is cut? Then it's just it seems to me, and of course it seems to me changes within the structure in the AO might be more readily accepted by the judiciary if it comes from this committee than changes Congress might be required of Congress, unless radical change by Congress. As I said, I didn't, in my talks with people on the Hill and in the judiciary, I haven't detected any zeal in Congress for creating an agency of, it's now I think $1.5 billion, and clearly with things that are being discussed, it's going to go over $2 billion, I would assume. Any zeal to create such an agency. The Public Defender Service would be a good model if it wasn't just one office. We have however many offices, 90 offices, and are we going to agree that in this theoretical ideal world, who's going to advocate for each individual office? And the public defender, and actually the Public Defender Service doesn't even include the budget for the CJA lawyers in the local courts in DC, which are also, that comes under the court's budget in DC. So the courts advocate for the CJA lawyers' budget in DC, and the Public Defender Service advocates for its own budget. And they have, I think, about 130 lawyers right now, so their budget, I believe, but they're always, every time I see, they're literally right next door to us, so I see the director all the time, and they go lurch from year to year, never sure of their funding and scared to death that they're going to be cut. They've been okay the past few years. They think it's very good that they get to advocate, but their budget went through a different system. It went through the mayor's office before they were allowed to advocate themselves, and they were afraid it was getting all tied up in politics at various times. So they welcome the independence of being able to advocate for their own budget. I would love the independence of being able to advocate for my own office's budget. Obviously, I'm sure all of us would, but you have this large institution. So the DC Public Defender, yeah, it's great for them, but it's also fraught with danger for them. And they change their hiring plans all the time based on what they think they will or will not get. And it goes through a completely different committee in Congress.
Is everyone in agreement, though, that some change from what we have now should take place? I mean, we have a committee, Defender Services, of nothing but judges, and there's no defender voice on that committee. It's part of the administrative office. So either having, from as little as having representation on the committee to making it an independent board like the Sentencing Commission or FJC, everybody's in agreement that some change needs to be made. Is there consensus at least to that?
Yes.
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 certainly.
I
As well
would-
as panel attorney representation, too.
Yes.
Defender and panel attorney representation.
A question that I have is, and this is basically with judges reviewing vouchers, but I think it goes much broader than this, is what information did the judges rely on when they're evaluating the CJA lawyers as to the amount of work that they put into a case and whether it's necessary and whether it's quality? I don't.
Well, you don't know, but once we put our robe on, our IQ goes up quite a bit.
That's what
and,
that was what I suspected, but I wasn't sure.
Anything for you? Gerard.
All right, very well. I do want to ask a couple process questions before getting to structure, but after hearing the experience in, what was it in Virginia or West Virginia?
Western District of Virginia.
Western District of Virginia, of having a lawyer removed at the time of jury selection on a capital case. These questions may sound rather mundane, but I do want to ask them. Now, as I understand, Mr. Capici and Mr. Heblick and Mr. Kamens, you do not manage your CJA panels, is that correct?
That's correct.
Okay.
That's
No,
correct.
no, we
You do, and,
do.
okay, then Mr. Kamens and Mr.
I mean, the
Capici?
selection.
Okay. And do you manage the panel itself and the?
Yeah, we have, we have a selection committee that a magistrate judge is a member of the committee,
Okay.
and ultimately the decisions are reviewed by the chief judge, but we are very influential in the selection.
Okay, well, my question.
And you need to
Go
speak
ahead.
in the microphone, everybody.
Need to lean up, yeah. My question is this, in at least 2, if not 3 of your districts, there's been at least an underutilization of experts and investigators, et cetera, and I'm wondering if that has anything to do with the fact that either you don't manage or the clerk assigns in your particular district?
Yes, Your Honor. We have a CJA supervising attorney. It was a position created about 4 years ago. And the CJA supervising attorney is acutely aware of the need to increase the number of resources. And again, as I previously stated, we're working together to make that happen. But it is her. She actually manages the CJA panel, and she is the one who processes the vouchers, but I am part of the selection committee.
Okay. And Mr. Heblick, I think you said in your written testimony that there's a failure to utilize some of those resources, but not a failure of availability. And I'm wondering, is that education locally? Is that education nationally? What do you see as the problem?
Well, certainly it's locally education, but as I learn what's going on in other districts, I didn't know that the Eastern District was having the same problem, but I think it's probably a broader problem than I would have suspected, the underutilization of resources.
Okay. And what do you assess that, or what do you assign that to?
I think basically the lawyers not being aware of the availability of the resources.
All right.
I just don't have any other information. I don't have any other information as to the judges denying requests.
Okay. That was going to be my follow-up question. Are there other issues? Are there denials of request? Is it cultural? Mr. Kamens?
We just had an assessment from DSO where they conducted a survey of our CJA lawyers, and the person from DSO said approximately 20% of the CJA lawyers said that they'd had problems with vouchers. He said that was actually a pretty good number, meaning 80% didn't, and I certainly have had, in preparing for today, I had CJA lawyers say that they've never had a penny cut from their vouchers, but it's judge by judge, it's case by case. The CJA panel representative, James Broccoletti, who testified earlier today, he said with one judge he had a case where he had to travel, and involving our office as well with a co-defendant, had to travel to Afghanistan, and the judge approved every voucher. And then he had a case where it was a simple drug case, and he had to meet with the client 5 times, and the same judge cut it. I think that there probably is some concern among CJA lawyers that because of their fear of not having resources approved, they simply would rather handle the case either without submitting a voucher for work that's done or simply by doing the case themselves. Now, there is somewhat of an apples and oranges comparison between our office and CJA lawyers. Our attorneys handle 80 to 100 cases per year, and the CJA lawyers on the panel, depending on how many cases they get, it could be 4, 5, relatively modest number. And so at any one time, if they're only handling one federal case, the resources that we have, the reason that we immediately put an investigator on a case is because we're trying to lower the workload for that assistant who has a number of other federal cases. And it may be that a lot of CJA lawyers, don't have that caseload. But it is something where I think if the vouchers were reviewed by someone other than the judge handling the case, either in our office or a person in the clerk's office, where there was confidence, I think, as in the District of Columbia, that reasonable requests, appropriate requests are going to be accepted, then I think that would certainly increase the number of lawyers who use investigators and experts and paralegals.
Okay, very well. Now, along the lines of resources, Mr. Kornbrath, I think you had mentioned in your written testimony that there were some issues with computer-assisted legal research. What issues did you have in West Virginia?
Well, I just want the committee to understand that a federal public defender attorney has unlimited access to legal research.
Right.
It's an invaluable tool.
And CJA?
They're either going to avoid the use of it altogether, or they're going to put the research time on their CJA 20 voucher. I just think it would make perfect sense to use the national contract, let the panel attorney access the same legal research because they're doing the same work, and it's going to increase the quality of the work product.
And is there and I'm asking out of curiosity, is there a reason that the national contract is not utilized?
I've been asking for years at the conferences we go to, why can't we just get a rider so panel attorneys can use the same system?
And the answer?
There's been no answer that I know of.
All right. Okay. We'll see if we
I
can get
think
one.
I think it's the provider, the Westlaw system.
And Lexus.
And Lexus, they're okay with offering it to defenders as part of the judiciary contract, but I don't think they want to open it up to 10,000
Private
lawyers.
practice.
They do get a reduced rate, but I don't think they want to open it up for free to 10,000 lawyers, whether that's right or wrong. It's a commercial business.
All right. Okay, very well. I think that's all I have for now.
All right, Dr. Rucker.
Thank you, Judge Cardone, and thank all of you for being here. I have just a few questions. Some of them are just fairly simple that I'd like to start with. Would any of you like to make an argument for why the Court of Appeals judges should be involved with approving excess vouchers?
The argument, I think, is that there has to be cost containment. There has to be some measure in the system that prevents, we don't have an unlimited pool of money. And so the question is, well, how do we devise the best system for cost containment? And the system that we have is approval from, again, I think, the removal of the approval at the district court level is I don't think makes a tremendous amount of sense because at the circuit level there's less understanding of what's going on in the courtroom on the ground. But I think the argument for it is, well, this is a measure of uniformly trying to contain costs in the circuit. I'm not advocating for that. I'm just saying I think
That's what I really want to know. Would any of you really support that?
Oh,
I mean,
no.
that's the position we're in right now. And as we've held these hearings around the country, we've heard a number of complaints about the Court of Appeals having to do this. Those judges really don't have any knowledge of the case, and yet sometimes they're cutting vouchers, sometimes significantly. So I just want to know if any of you thought there's any value added to having the Court of Appeals judges review those vouchers.
I think there has to be some oversight. I know that there have been problems around the country at the state level where You might have an attorney who's billing 26 hours in one day and crazy stories like that. But perhaps an audit team from DSO, maybe the price of membership on the panel is that from time to time you may be audited to make sure that you're billing properly. But again, I think that it doesn't make sense to have the cutting take place 2 levels or a level above the trial court.
Okay, another, I hope, fairly simple question that we've asked even earlier today of some of the defenders who are before us and that we've asked before. How often do you have service providers on your cases? And some of you talked about that just within the last minute. And the response we got before was most of the defenders have an investigator or paralegal basically assigned on every case. Why should we not be doing that for the CJA attorneys? I know one of the responses was that their caseload may not be quite as high, but are there any other reasons why we shouldn't be doing that and expecting them to request those?
The only reason we have had experts denied in our district is because the district court judge just didn't feel he or she had enough information to make a decision. All they want is, what's your theory of defense? What's the relevance? How can this expert help you out? When that information is provided, it's readily agreed upon. There's really no pushback. They just want that information. You know, if I say I need a forensic psychiatrist for $15,000 and that's all I say, it's hard to evaluate whether that's going to be, you know, worthwhile or not. So the more information the judges have, the easier it is to get those approvals. Same with the investigators. How many witnesses do you have to talk to? Why? And where do you see the case going? We're getting no pushback from the judges as long as they have the information to justify it. And that's at the circuit level too.
In your district, Mr. Kornbrath, the usage rate is about 11%, so
Right.
that's 1 in 9 cases. You think that's what
Well,
they should be doing?
Like I said in my written remarks, every district is different. When I was an assistant defender down in the Southern District of West Virginia, plea agreements were extremely open-ended. You had no idea what relevant conduct was, what the sentencing guideline calculations were going to be. You went in there with question marks. You had to go out, investigate historical relevant conduct witnesses, guideline increases. In my district, the prosecutors have very specific plea agreements where you know exactly what the drug weight is. And in many cases, it's what was seized, measured, tested. There's no ghost stories, as our clients call them. So, you know, in those types of cases where you have 3 controlled buys on tape, and that's the only drugs we're using against you, perhaps you don't need an investigator. Our office takes most of the cases that require forensic psychiatrists and psychologists, the child porn cases. There's usually not a conflict where you have to farm the case out, so it's handled in-house. I don't see our panel attorneys getting many of the same types of cases we get. I think that might be one explanation for why it's not as prevalent. Training matters too. They've got to know the money's there. They've got to know the process to ask for it, and they have to understand that they'll be met with a receptive audience.
So do you think this is possibly part of a training issue that Mr. Heblick was talking about?
Definitely, that's part of the mix.
Okay. Let me follow up with this. And Mr. Kamens, in your written testimony, you mentioned self-cutting, and that was at least somewhat prevalent within your district. We've heard about this before. I'd like to ask you to comment on that, and then I'd like the rest of you to comment how prevalent that is, you think, in your districts.
Well, you know, in talking to CJA lawyers, they've told me that they do that, and I think that I also heard an interesting story from a CJA lawyer who said, and I'm not sure I put this in the written statement, that they had a case, they submitted a voucher, and then they had reservations. They thought wasn't that they had asked for amounts that weren't due, but they thought that the judge might think it was too expensive. And so they revised the voucher, brought it down. The judge actually gave the higher amount from the unrevised voucher. So the judge thought that was a reasonable amount. It was the amount that the lawyer had requested. But that same lawyer told me in another case that it was an expensive case. It was a case that there were hearings, there were experts that came to the hearing, and because of how much money was being asked in the case, the lawyer was aggressively trying to appear reasonable. It was over the cap, but and gave an expert fee, which was I think it was something that was $2,800 for a mental health expert from UVA to travel to Richmond. He didn't even have the money to pay for the mileage to come to the court. I think it is something that happens on a basis where if a lawyer believes that the lawyer is going to cut, if the lawyer believes the judge is going to look askance at the amount of money that's being requested, then they're going to moderate the amount of money that they're requesting. If they feel like they have a judge who's going to be receptive to reasonable amounts, then they won't self-cut.
Let me just follow up on that before I ask the rest of you to respond to that. So that person was doing that in response to the cap, although you said they were over the cap. Did they cut it down under the cap, or was
Two
it
different
still above?
cases, I think,
Okay.
and so there are certainly cases where, and I think the CJ panel rep, Mr. Broccoletti, may have mentioned this. If he didn't, he told it to me. If a lawyer has a case that is near the cap or just over the cap, then they will often reduce the amount of the request under the cap so that they don't have to deal with the added bureaucratic hurdle of being over the cap. But I think that, again, as the lawyers tell me who are on the CJA panel, this isn't often a tremendous money-making proposition. They're doing this part of their work because they want to do it. I mean, you heard from the CJA lawyers here today. They don't make a tremendous amount of money. They have to have part of their practice be in private practice, but they do this because they want to do this type of work. And so it's not about scratching and getting every penny that they may have expended in the particular case. But the amounts, the caps are absurdly low. We all know that. And I think that we should try to devise a system that adequately provides money for CJA lawyers who are doing this work in a reasonable way. That's obviously not what the market would pay, but doesn't penalize lawyers for engaging this type of work and doesn't create incentives for them to cut the amount of money that they're requesting to extraordinarily low levels. I think it affects the quality of the panel.
All right, thank you. Would the rest of you like to comment? Are you seeing self-cutting?
We see a little bit of it in our district. Some of the CJA lawyers have told me that they've done that they've cut back to the cap so they don't have to wait to get paid, go through the excess compensation system. Jeremy mentioned about the case budgeting lawyer in the Fourth Circuit. This is something new. And my information that I've gotten from the CJA lawyers is that ever since the case budgeting lawyer has come on board on the Fourth Circuit, that has really improved things for the CJA lawyers. That the guy is Larry Dash. He was in Jeremy's office, came out of the defender's office, and so he has a lot of experience, and I think has really been able to. Not that it was needed, but perhaps maybe educated some people as to what lawyers might actually need to do in some circumstances, and has been helpful to the lawyers getting their cases budgeted, getting more expert requests approved, and in dealing with excess compensation requests. So I think that's, in looking at things that might help, I think that is certainly one of them, having somebody there whose function is to deal with those issues and has the background and experience to make it work.
No self-cutting in our district, but again, in our district, the judges require them to come for pre-authorization. Let me know when you're at 15,000, let me know when you're at 20,000, so again, it avoids sticker shock.
I only personally know of one instance, but that's not to say that it doesn't happen more often. It just hasn't come to my attention.
I don't think there's any, other than what Mr. Brodnack said, that its limit is now $10,000. If the voucher's $10,100 or $10,200, the lawyer might say, just give me the $10,000. If it's 10,800, 11,000, they're not doing that. I've never seen anyone reduce it more than $100 or $200, and there's certainly no, that I know of, other kind of reduction in vouchers.
In complex cases, some of the judges will require interim vouchers to be submitted every 30 days or 60 days to keep a handle on it, and that seems to help.
And just one last quick question. Comment was made that the $10,000 cap is too low. Any suggestions on what that cap should be raised to?
I would say at least 15, if not 20. That cap is old, and it hasn't gone up, I think, proportionately to the rates. I think it went up $100 the most recent time. So I would say 15 and possibly 20.
I think
Anybody
it
else?
would be easier as, again, e-voucher is going to be online. You're going to see, what cases are getting billed at. You might be able to use that data to come up with another figure. I don't know what that figure is, but it certainly should go up.
All right, thank you, Judge Cardone.
Thank you. I have a question based on, I guess, sort of a theme that I kept hearing, which is training for the CJA attorneys, particularly in the use of investigators. But I'm a little perplexed because you guys are all defenders, and it's my understanding locally you're responsible for training and the idea of the local CJA panel attorneys get training by you and learn how to use investigators. So if they're not getting trained, isn't it your fault?
In my district, it's not our responsibility.
Oh, so you don't get any funding from DSO to do training locally?
We pay for that, don't we pay for the?
We do. I mean, it is, I think it is part of our
That's why I
responsibility
was
to
asking
provide
about
training.
management of panel. Who's managing the panels? I guess that was my question.
Right. I mean, we don't manage the panel in terms of assignment of cases or reviewing vouchers or anything like that. It is a responsibility, I think, of the defender to assist in providing training. The question is there going to be some level of training that should be required before someone's on a panel? I think it varies by district. It varies by CJA plan. There isn't a lot of the selection of who's on the CJA panel, for example, in my district, it's completely opaque in a couple of the divisions. But you're absolutely right. Part of our responsibility is to provide training to the panel. In our district, we try to make sure that we provide at least 12 hours of training for a CJA panel a year. Part of it is an 8-hour course that we do over 2 days with the Western District once a year, and we also do a 4-hour course in the fall. A lot of the training that we do is substantive. It's not specifically with respect to the meta issue of here's how you should apply for this amount of money for this work that you've done. We have had Larry Dash, who was newly appointed from the Fourth Circuit, come to talk, I think last year. I mean, he's only been on the job for a year and a half or so.
But isn't the use of experts and investigators and staff substantive? Doesn't that go to the substantive issues?
Absolutely. And we have had substantive training on that. I
Okay.
think, I think it's one of those things where individual lawyers absolutely need training. I'm not sure there's any debate about that. We should all be responsible for helping to assist and train the panel. Is that an issue for the commission? I don't know. I mean, it's something that we should be responsible for and do and should focus on.
It's part of our mission statement. Brian and I put on a comprehensive training every year. We take turns hosting. But I think we discussed this earlier, Your Honor. It's, I think, a cultural issue. When the folks from the military spoke, they talked about how difficult it is to get experts and how you have to lay your case out. But I can tell you, having been in a similar situation and served on active duty, we were constantly asking for experts. We were aware of the value of experts. We were If we didn't ask for an expert, our boss, the Chief Defense Counsel, would say, why are you not asking for an expert? So, and certainly in the Defender's Office, I think that that's also a question when we have our Friday meetings where we discuss our cases. Well, it's time to get an expert on the case, and it'll be brought to my attention as the defender to approve it. Why the panel attorneys are not using experts, remains, I think, to a certain degree, a mystery, but I do think there is a cultural issue there, as well as an issue with regard to the cutting of the vouchers or the approval process, that perhaps they're hesitant to ask for an expert that costs $10,000 or $15,000 when the bill that they're going to submit may be much less than that.
Well, and I'm going to express a bit of frustration here because we have heard about the lack of use of experts, and we've had both the FPDs and the CJA reps who are, I mean, if you guys aren't advocating, then who's supposed to do it? I mean, I'm a judge. Am I supposed to advocate for you guys to use experts? I mean, I understand, and if you can tell me that you guys are applying for experts and I as a judge are saying no, that's a different issue. But if you guys aren't asking because you're afraid, or if you're not asking because you're not trained, why should we even care about that? I mean, you guys got to ask, or you got to give us some reason why it's not being done. And I'm just, it's like we're going in a circle here, and I just don't, I really am trying to understand, and I want you to understand this committee is charged with trying to come up with a better system, but you guys can't just say it's a problem, it's a problem, it's a problem, and nobody takes any responsibility. Any thought?
One of the advantages that we all have is that if we need to have an expert in a case, we don't have to ask you.
Right.
We have a budget for it, and we can decide whether it's an expert that might be helpful in the case. And I think the question that you ask is a good one. Why aren't CJA lawyers asking for more assistance in the cases that they have? I think there's a variety of reasons for that, but one of the structural questions is, should that question go to you in a case? Or should there be, even if it should go to you, because you are the judge that's handling that case and have a great deal of knowledge about that particular case and can have a good independent view of what experts are going to be required, should there be potentially some additional information from an objective source, from a defender or from other CJA lawyers that could help the court decide whether to approve that request? I don't know. Should that request at all go to the judiciary? And that's the question, the structural question, I guess. The other questions about maybe these lawyers should be better lawyers. I'm not sure you guys can answer that question. I mean, that is something that is a different.
Well, there's a legitimate structural question there, but when the utilization of experts are somewhere in the neighborhood of 8 or 10% or whatever, and we're asking, have you been denied? And the answer is no. I'm not sure that is ultimately it will be a structural question that we'll have to answer, but it's a little bit bothersome when the question is being asked, have you asked and been refused or anything, and the answer is no. Where do we go?
I mean, I'll take responsibility. I think it's the defender's responsibility to get that information out to their panel lawyers, and frankly, nobody else's almost. Other people may help or aid in that, but if the defender's not telling their panel lawyers, these resources are available, and you should be asking for them, and especially with the e-discovery cases and the resources out there. I'm not satisfied. I'm glad that our district has one of the higher, if not the highest, use of expert service providers, but I still think it's way too low. And I will emphasize that when I get back. But I think it's absolutely the defender's responsibility to get that information out to the panel. I don't know how anybody could disagree with that. I'm sorry to say that. Whether you administer the panel or not. We have email lists. We send, I think we send more than one email a day to the panel about various legal, substantive, procedural issues that they should be aware of. You can't do anything if they're gonna not do anything with that information, but if you're not getting the information out to them, that's absolutely the defender's fault.
Judge Cardone, can I jump in here for a minute?
Yeah,
on
I
that?
just, well, okay, go ahead, real quick. Sorry, because I had a follow-up question here, but go ahead.
I think the question, in some ways, that we're trying to ask is based on the fact that in some districts, what we've heard is that folks on the panel are not asking for experts for a number of different reasons. One may be because they've asked a number of times for an expert and been denied. Another may be because they have to outline the theory of the defense or tell the judge something that they don't want the judge to know in order to obtain an expert. Another may be because it increases the cost of the case. And when the judge makes a decision about how much that lawyer should get paid, they factor in the amount that the case has cost for an expert, whether it be a psychologist, an investigator, or even something more expensive like a forensic accountant. So I think what we're really trying to get down to, I mean, obviously there may be an issue of training, and that may also be financial. We don't really have to discuss that, but let's remember that when we go to training as federal defenders or as assistant federal defenders, we get paid. We have a salary. Somebody pays us, every day that we're there. They fly us there. They pay for our per diem. They pay for our hotels. And we are not losing money, which is the private attorneys are, when they go to training. So let's leave that aside. But what we're trying to figure out is that if you're aware of any issues in your districts in which folks may not be asking for these experts, especially in districts where the number of people who are requesting are very low because of any of these issues.
Well, I mean, I think I provided an example in my written testimony of a request for expert that was very much below the market, and the approval was further much below that. I think that there is a category of lawyers who are affected by the approval process for experts that results in them not asking for the assistance that they should have in a particular case. Now, there are certainly other issues, but there is a subset of lawyers here who either because of their view that the request will be denied, or their view that they can't find an expert for the amount that the judge will approve, don't ask for the assistance that they need.
And so I guess I have a follow-up to that, because then I heard Mr. Kramer talk about his district and his judges. And, I have to say, I come from a very heavy criminal docket. I have never seen a request, I'm trying to think for sure, but $20,000 for an expert in my district, there would be some shock and awe. And so I guess it seems to me that it's sort of this inbred cultural, I'm not going to ask because I know it's going to be too much. I'm not going to ask because it's affecting my voucher. Or I live in a great place where, the judges get this concept and they're not going to quash my request. And so can any of you speak to that? Because I really have a concern that it's much deeper than just a lack of education. I have a concern that people sort of self-regulate because they know they're judges, and maybe I'm wrong here, but I want to hear it from you, because if I lived where you live, I'd be asking for experts every day if I could get $20,000 to help me on a case. But if I lived where some of the other ones, and we've been around the country, I would never ask because that judge is going to think I'm a troublemaker. So any sense of that?
Can I go back for, it's answering this. There was about training for judges and why judge. There used to be at Baby Judges School half a day devoted to CJA issues. I know that simply because I used to do it, and please believe me, it's not anything about the quality. I'm free when the trainings are in DC. I'm available and I'm free. And then they stopped doing that, and I asked them why, and the answer was that they shortened the baby judges school because of budget issues, and one of the things they cut out was the half day for CJA, and that cut a whole half day, and the judges aren't getting the training they need.
That's true.
Then there used to be a series of criminal justice management seminars that were 2.5 days, 2 or 2.5 days, and I used to go to those, and they were all over the country, and there were about 20 judges, and I was there for the whole 2.5 days giving them the viewpoint from the CJA and why an expert would be. Those seminars went by the wayside about 8 or 10 years ago when the budget cuts were made. So I do think that the judiciary itself bears some responsibility for educating judges about the need for these, and that was happening for a while, and that fell to the wayside for various reasons and never came back. So I think you're absolutely right. There's the difference in cultures is astonishing to me all over the country, how, and disturbing all over the country, how those requests are treated differently and the way the panel's treated differently in some districts. But I think the judiciary bears some responsibility, and that the guidelines, the CJA guidelines, ought to be a lot stronger in telling judges that they, as I discussed earlier, presumption of a lawyer who's worthy to be on the CJA panel is worthy to be trusted and worthy to be trusted in how they're defending their case, and that the presumption ought to be that it's approved, and if not stronger. I mean, you can't just blanket approve everything, but it's partly the judiciary's fault too. I think it's partly the CJA lawyer's fault, it's partly the defender's fault, but I think it's also partly the judiciary's fault.
Any other thoughts?
Something that might help is I haven't looked at the rates recently, but it used to be that there was a sort of a $300 default thing on experts that you could incur without prior approval, and then there was the cap was I think 7,000 or maybe it was lower than that that the district court could approve, and everything else for experts had to go to the circuit court. And it is, I don't know, is that number right? 300? Is that
800 now.
Is that 800 now? If it maybe more substantial than that, you really can't get much for your money. And if they got used to it, I think if they got used to it, I do think, I think it is cultural more, at least in my area, because they're used to state practice. Virginia pays, I think they're 49th in compensation for court-appointed lawyers. I mean, they're down there, and so a lot of these lawyers are doing. For $120 for a misdemeanor, for $500 for a manslaughter trial or whatever, they don't do much. They just absolutely don't. They read whatever discovery the Commonwealth provides, and then they read the pre-sentence report. It's really like that, and that is, I think, what they're used to. And
Can I ask you to lean forward?
When they come into the federal cases, unless really you rub their nose in it and say, no, this is all available, it's hard to get them to change what they do. They simply don't realize that even if their client's going to get convicted, and of course 99% of them are, that it's still very worthwhile to have somebody doing investigative work for mitigation work. They just, they're used to just relying on the probation officer's pre-sentence report. And you can't just rely on the government's discovery and just rely on the pre-sentence report. You have to do your own investigation. I think they're just not used to it. And maybe if those numbers were raised a little bit, maybe that would help encourage them to, in every case, or almost every case, go out and get it. They're not used to working. Most of them, I think, have never had an investigator work on a case. I would guess 90% of them have never had an investigator work on a case. They don't know one. We can find them for them, but they don't know people, and they don't know how to use them. I mean, that's sort of, criminal defense 101.
Keep the information flowing from the national level to the districts I mean, once a year, both the district representative and the defender should get those numbers and see where they are, to see whether they're rising and falling over time. I think back 5 or 10 years ago as a defender, I didn't have access to that data the way I do now. It seems to be more recent where you're getting percentages of investigators and experts, and that's very beneficial. Christian and I last year, we had a whole block dedicated to CJA billing issues. I mean, we would read a CJA 26 memo where you're trying to justify going over the voucher amount. Read one that's terse and not very informative, and one which just jumps off the page. It's compelling and it's necessary, and you're trying to educate your panel attorneys. You're going to get paid if you take that track, if you will. So it's an educational issue. We need the information to prod the panel attorneys to increase the numbers.
Your Honor, I had no idea that this was an issue until, fortunately, I think this committee brought the issue to the surface. I know that the CJA panel representative from my district came back from San Francisco, and one of the first things he told me was, our district has a very low rate of using experts, and that prompted a discussion with the CJA supervising attorney. So at this point, my opinion as to why they're not using experts is based on my observations as opposed to having spoken to the panel, and that is something I certainly would like to explore and will.
Thank you. Anybody have any questions? Anybody? Professor.
I think we've actually covered what I was going to question about.
All right. All right. So, on behalf of the entire committee, thank you very much for your time. Again, every time we do this, we learn a little bit more. When you guys go back, if you get any more information regarding these issues, please feel free to submit it, because we really do appreciate the information. But thank you.
Thank you.